welcome to today's webinar. My name is Jeremy Richards. I'm an attorney with Richards and Drusik, where we only practice U.S. immigration law. And today we are going to be discussing the transition from a TN visa to a green card and the common pathways to do that, as well as the categories you can use to go to a green card, such as employment, family sponsorship, some common challenges that you can run into when you're going through this process. And then we have some Q&As, standard Q&As that individuals ask during this process. And if there's anybody who's with us today that would like to ask questions, you're welcome to ask questions as well. And it's not just me today. Along with me is Rachel. I'll allow her to introduce herself.
Hi, my name is Rachel Sparacino, and I'm an associate attorney here at Richards and Drusik. I've been working with the firm for about 2 years now, so I have helped several of our clients go from TN to green card as well. So I'll be joining Jeremy in discussing this topic today.
And welcome everyone who's decided to attend as well. We handle a lot of TN visa situations, and we help individuals transition from TN visa to green card on a regular basis. And there's some misconceptions out there about this process and whether or not it can be done. Although there are complicating factors when you go from a TN visa to a green card, it is absolutely a pathway that you can take either through employment or family sponsorship. So we're going to go over that today, hopefully clarify some of those misconceptions and help you understand the process and answer whatever questions you might have with that. So the two most common pathways to go from a TN visa to a green card are either through employment-based sponsorship through a process that is called PERM, and there are also non-PERM related ways to go from a TN visa to a green card, and some of those include self-sponsorship as an employee or as an individual that possesses certain abilities that you can show the government that would allow you to skip that PERM process and self-sponsor, as well as your standard family-based sponsorship categories. And the first one we'll go over is PERM. And what is that? So PERM is a process through which an employer does what's called a test of the labor market to determine whether or not there are willing and able qualified U.S. workers for the position that you're trying to fill or trying to offer a foreign national. And they require employers to go through certain steps to verify that they've done an adequate job search and weren't able to find U.S. workers before they offer a permanent position to a foreign worker. And through the PERM process, there's various steps that you take. The first step in the process is what is called a prevailing wage determination. Now, prevailing wage determination is sort of a minimum wage. The prevailing wage determination tells the employer what wage they have to pay this foreign national for that position according to the degree requirements, the experience requirements, the area of intended employment, as well as travel requirements and other factors that are used to determine what an acceptable wage is for the position. And that is area specific. So they do a calculation for the area of intended employment, and they take all of the requirements that the employer is posting for that position to come up with that wage. And they use their database of reported wages to determine what that wage should be. And the employer has to pay at a minimum that prevailing wage to that foreign national. You can pay above it. They can pay as much above it as they want, but they can't pay below that prevailing wage determination. And that's the first step because that wage is used as part of the recruitment process. When the employer recruits and they have to appraise U.S. workers of this job opportunity. And in that recruitment process, not only are there areas where the wage is disclosed for the position, but also what are those minimum requirements that the employer will accept for the position, such as a degree requirement. Some positions might require a PhD or a master's degree. Some might be a bachelor's level. Some may be even less than that. but that recruitment process, the job ads that are used during this recruitment process must contain specific information to properly appraise U.S. workers of what this job entails and how they might qualify for it, in case they are interested in the job, so that they could apply for that position. And that recruitment phase is governed by the Department of Labor, and it's actually a very antiquated process. For example, 2 of the recruitment requirements are Sunday advertisements. You have to use 2 Sunday ads. How many people look for jobs in Sunday ads anymore? I don't know. I can't imagine it's very many. And there are other advertising mediums as well that you can use, such as online advertisements, job fairs. You could even recruit through TV and radio if you wanted. But they have all sorts of advertising mediums that you can choose from to properly, and it's what they call appraise U.S. workers of this job opportunity. So if they want to take that position or it's something of interest to them, they can submit their resume to it. So during that recruitment process, the employer would collect the resumes of all of these potential applicants and determine whether or not the potential applicants meet those minimum qualifications for the position. And if an employer runs this recruitment process, and of all of the individuals who apply, all of the U.S. workers that apply for this, potential U.S. workers that apply for this position, none of them meet the minimum requirements for the job, then it enables that employer to move forward with what is called labor certification. Now, it's important to understand that it's the minimum requirements for the position. And it doesn't make sense if you're an employer how this process works at all. We talk to employers and they say, well, I don't really use strict criteria like that. We'll post a job based on a degree and experience. But when I interview people based on personality, intangibles that you can't put in a job posting. That's not how the Department of Labor process works, unfortunately. You can only make a determination as to whether somebody is qualified for the job ad based on tangible requirements that you can quantify. You can't eliminate somebody on other factors that aren't in that job ad. So it can be a very cumbersome process for employers, but it's the process set by the Department of Labor, and you have to follow it strictly. So to eliminate somebody, for example, somebody would apply for the job and the job advertisement says that the position requires a bachelor's plus 4 years of experience, and those 4 years of experience have to be in architecture, for example, and you have to have a degree in architecture. Well, if somebody applies and they have an architectural degree and they only have 1 year experience, well, they don't meet the minimum qualifications for the position. They're lacking 3 years. So it can be as simple as that to eliminate people. If on the face of the application that individual doesn't meet those minimum requirements, they can be eliminated from the candidate pool. And as you review candidates, as the employer is going through that, if they can eliminate all of those applicants based on not meeting those minimum requirements, or if there is somebody who does meet those minimum requirements and they offer that individual a position and they reject the position, then the employer can move forward with labor certification and request that this position be given to the foreign national. And that's what the 9089 labor certification is. The employer will take all of these recruitment efforts. They will provide the list of the applicants' reasons that they were disqualified, and that's submitted to the U.S. Department of Labor. And then the U.S. Department of Labor will then provide certification and say, hey, okay, you submitted all of this. We agree, we reviewed it, and it looks like you did the recruitment efforts properly. We're going to certify this. Now you can take your certification and you can go to U.S. Citizenship and Immigration Services, and you can ask for their approval as well. So you're not dealing with one agency here, you're dealing with two. First, labor certification with the U.S. Department of Labor. Second, the I-140 petition with U.S. Citizenship and Immigration Services. And they're really looking at two different things here. Labor certification, Department of Labor wants to make sure that you're doing a fair recruitment and you're making this eligible U.S. workers. That's what the main concern of the Department of Labor is. Now, USCIS, on the other hand, they will accept the certification for the Department of Labor and say, okay, we see you recruited properly. Now, what they're going to do is they're going to look at how you recruited. They're going to look at that job ad. They're going to look at those minimum requirements that you posted, bachelor's degree, 4 years of experience in the example that I gave. And now they're going to compare it in this I-140 application against the foreign national that you want to hire. So with that I-140, you say, hey, here's the labor certification from the Department of Labor. Here's the foreign national that we want to offer this position to because we didn't find any U.S. workers. And USCIS will then look very closely at that individual to make sure that they also meet those minimum requirements. And they will look at the degree, make sure that degree is a match. They will look at the experience letters and make sure that those experience letters have the minimum requirement for experience, and that the duties and the former tasks that the employee performed with former employers also line up with any specifics that you would have put in that job ad. So they'll look very closely at that foreign national, make sure they check all the boxes as well before they will approve it. Rachel and I are actually working on a perm case right now, and the employer posted a certain way and required 5 years of experience, and they have this foreign national that they want to move forward with. The foreign nationals since provided their experience letters, and if you calculate the days, because USCIS will do this, they'll calculate every single day, the individual is short 2 months. So either they need to come up with 2 months somewhere, or they could potentially be ineligible because they don't meet the minimum requirement that the employer has of 5 years. They count it to the day. Also, the employer posted some specific requirement or specific skills and knowledge that this employee should have in their field of expertise. And there was a couple of them that were listed in the job ad that don't show up in these experience letters either. Well, USCIS will identify that. They need to see that in that former employer letter or their proof of experience. And if they can't line it up, then it could result in a denial of that I-140. So you have Department of Labor making sure there's a fair recruitment process. And then you have USCIS making sure that a foreign national that you're offering this position to meets those minimum requirements. Then once USCIS approves it, it doesn't really give you anything, which is funny. You go through 2 steps of a process and you don't walk away with any status yet. What it does is once that I-140 is approved, now it enables the foreign national to then act on that I-140 approval and then request a green card based on that approval. And they will then by themselves go to USCIS and say, hey, my employer filed the I-140 petition for me. It was approved. Now I want a green card based on that approval. And now that foreign national, along with any qualifying family members, would submit their applications to get their green cards. And that can be done 2 different ways. It can be done through what's called adjustment of status. So if those individuals are inside the United States in legal immigration status, they can request to adjust. So in this case, we're talking about a TN. If you're on a TN, you would file what's called the I-485 adjustment of status application with USCIS and say, change me from this TN over to a green card. Adjust me from a non-immigrant to an immigrant in permanent status in the US. Or consular processing, where you request that this application be processed overseas at a US consulate. And in general, adjustment of status is faster than consular processing, but there are times where consular processing can be faster than adjustment of status. And also, there are reasons why you might want to choose one over the other. This final stage and whether or not you can commence it is dictated by what's called a priority date. So, and the priority date is determined by a country of birth. and that can be confusing. We have a lot of Canadians who weren't born in Canada. Maybe a Canadian that was born in India, for example. We see a lot of Indian-born Canadians. The U.S. Department of State, so now we're throwing in another agency here, issues what's called the Visa Bulletin. And on that Visa Bulletin, it divides the category, employment-based green card categories into subsections. And then those subsections are then divided by country of birth. And where you were, every country is allotted so many immigrant visas a year for each category. And if you are from India, for example, the current backlog for an employment-based green card through PERM, I think the standard processing is at 17 years right now. I can't remember.
At 2012 is where they're looking at.
So they're processing cases from 2012. So 13 years, let's say, depending on where you're at, right? 13-year wait. Whereas if you are from Canada and you were born in Canada, the wait time right now is just over, it's about 1.5 years. So it's significantly less wait time. How do they determine that wait time? Well, when you file this when this labor certification, that 9089 labor certification is filed, you will be given what's called a priority date. That priority date is your place in line. That priority date would then be compared against this priority date from the U.S. Department of State to determine when they're going to process your case. Like going to the DMV, you sit in line. If you're number 1, well, you're going to be pretty quick. Well, if you're in this case, if you're number 13,000 or whatever it is, well, you're going to be waiting a while until you get called up in line. And then every month they publish the Visa Bulletin, and those dates can either move forward or move backwards depending on how many people applied that given month. And that dictates how long you're going to wait in line. But if you are Canadian born, right now it's roughly about 1.5 years before the priority date could potentially become current. And not too long ago during COVID, for example, or pre-COVID, these priority dates were often current. And individuals, as soon as they had the I-140 approval, were able to immediately file for either adjustment of status or consular processing. So if you're in the US, you would file adjustment of status through form I-485 once that priority date's current. If not, then what happens is USCIS will notify the consulate that you want to do consular processing, and once your priority date's current, the consulate would notify you, and then you'd move forward at that point. Now, yeah. Oh, this is Rachel. Turn the time over to her.
So as mentioned earlier, there is employment-based sponsorship through your employer through the PERM process, but you can also be sponsored without an employer and without going through PERM. And the ways that we see those come up for individuals who are on TNs are going to be on the 3 categories of either EB-1A, EB-1B, and EB-2. Your EB-1A is going to be your individuals of extraordinary ability, and this is something that you can self-sponsor. You don't need to have your employer filing this for you. Your EB-1B of your outstanding researcher or professor still does require you to have an employer. And then your EB-2 national interest waiver is again one of those areas where you can self-sponsor. Even though it is still that EB-2 category, there is no PERM requirement for it like a traditional EB-2 green card. So going into them a bit more in depth. So the EB-1A, extraordinary ability, this category is for individuals with extraordinary ability, often called the Einstein visa, and it's designated for individuals who've demonstrated a sustained national or international claim in their field of expertise. So the way USCIS adjudicates these cases is they first look to see that the applicant has evidence of extraordinary ability in either science, art, education, business, athletics, and they have to provide proof of that extraordinary ability. And the way that they can show that they are extraordinary is either through a one-time achievement, which is things like a Pulitzer, an Oscar, Nobel Prize, Olympic award, or by meeting 3 of the following criteria. So we have them listed out there, but they're going to be evidence of receipt of lesser nationally or internationally recognized awards. And these awards have to be received for excellence in the field of your endeavor. We recently had a case where an individual was trying to show grants that they won, but because those grants weren't given to them because they had excellence in their field, USCIS determined that those grants didn't meet the threshold required to meet this criteria. Another one that you can meet is membership in associations which demand outstanding achievement of their members. So if you are just a member of, like Jeremy and I are members of the New York State Bar, that doesn't require us to be excellent as lawyers to become a member of that organization. They're looking for membership that an organization has come to you to say, you are very excellent in your field, please be a member of our organization. Then you have published materials about the individual in professional or major trade publications or other major media. This does need to be major media, thinking the New York Times, Washington Post, BBC. It can't be simply just like your local newspaper or an article about you on, say, a school website. Another criteria you could meet is judging the work of others. We also have original contributions of major significance in your field. So if you've had a patent that you created, or if you developed a new procedure that's, say, used in the medical industry or a new medical device, that would reach the threshold of an original contribution for EB1A purposes. There's also authorship of scholarly articles or in professional journals or other major media. So again, this has to be major level media. It can't just be a blog post or a school website. You can also show that you've displayed your work in artistic exhibitions or showcases. So this is kind of leaning more towards the arts and athletics section of the criteria. You can show that you have performance in a leading or critical role of an organization that has a distinguished reputation, and that distinguished reputation has to be shown by objective opinion. So if you have, say, a company who on their company website lists all of these awards that they have won, USCIS says, well, that's very subjective because it's your company saying that they have a distinguished reputation. You need an objective third party to come in and say, yes, this is a distinguished organization. And then you have commanding a high salary. So if you're coming to do a role where, say, you're an opera singer and you get paid $1 million for coming to perform, USCIS will look at what a standard opera singer is supposed to be making. They'll compare it with the Department of Labor, look at the wage levels in that area to see if the salary that you're commanding is indeed higher than normal. And that's higher than normal to reflect your level of professional ability in this industry. And when they look at that as well, they're only looking at your base salary. So if you're getting bonuses or any other type of commission, they don't count that towards the commanding of a high salary. The final criteria that they will look at is that there's commercial success in the performing arts. So if you are a musician and you sell out at the box office, they'll look at that in order to determine if you meet the criteria. So if you don't have one of those one-time achievements, you need to meet at least 3 of the following 10 that are on that slide. And not only do you have to meet those, you then have to show to USCIS that you've sustained that acclaim. So if you've only just met that requirement and it's been, say, maybe 5 months since you've had that, you haven't shown to USCIS that you've sustained this acclaim. They want to see it over, I would say, at least 1 year, maybe 2, over a continuous period of time, that you are continuing to have this high level of extraordinary ability, and then they'll approve you. And once they do, you still have to come in to work in that intended area of your expertise. So you can't just say, I'm an amazing soccer player and decide that you're not coming into the US to play soccer. you have to continue to be a soccer athlete when you come here. And then we'll switch it back over to Jeremy.
Yeah, we've done many EB1A applications. We had one actually recently, and Rachel's going to talk about national interest waiver here in a minute. But that individual is approved for a national interest waiver, which is pretty significant, as you'll hear later. And that individual said, you know what, I was approved for national interest waiver, but the wait time for that is longer than it is for the wait time to get a green card if you're extraordinary ability. So they wanted to try extraordinary ability. So we said, if we can try if you want, and you know, we don't think you meet that criteria yet, but we can do the best we can to argue it for you. And the government accepted all of the criteria that we were able to argue on behalf of this individual. And then at the end, the last criteria that Rachel was discussing, you have to have sustained merit in your industry. This individual, the government came back and said, we believe that you're extraordinary. We have no doubt that what you're doing is amazing, but you haven't been doing it long enough. Do it a little bit longer, then we'll consider approval. So the client was very happy, like, oh, wow, I can't even believe we got it that far. But you have to have been doing this for some time. You can't, you know, unless you just want a gold medal. No, that's a different story. Then you just show that gold medal and you're on your way. So EB1B is another category that's available. And EB1B is for those who have established themselves as experts in their field internationally through research and academia. Okay, these individuals have demonstrated that through their body of work and contributions to their field. So it's somewhat similar to an EB1A, but it specifically deals with research, as it would allude to here. The first criteria is that it has to be international recognition, and that they are recognized internationally for outstanding achievements in their specific area in their specific academic area, and have to be recognized internationally. So that's a pretty big standard. This would go back to a similar criteria that Rachel discussed about newspapers. Well, if you were recognized locally in your local newspaper for something that you did, that doesn't count. Your recognition must be on an international scale for it to be accepted. The second criteria is specific to teaching or research experience, and that the individual that would be considered for outstanding professor researcher has to have worked in that field for a minimum of 3 years in that specific area of research or in that specific academic field before they can be considered. So if you're a recent graduate, you're not going to be that, or you just started researching, or you just received your first offer as a professor, not yet. Now, after you've been working there for a few years, 3 years at a minimum, then you'd become eligible. And just like the PERM that I discussed earlier, this experience must be well documented. You can't self-attest to these requirements. You can't just show a resume and say, hey, I meet it. Look, I have 3 years of experience, or as a teacher or researching. You need to have letters that attest to it and make specific attestations to your experience and research expertise. No self-attestation is allowed. They won't accept it. And the other part of this, and then now this one is not self-sponsorship. Your employer would sponsor you for outstanding professor researcher. You must have a permanent job offer from an academic institution or a research organization that wants you to be a permanent employee of theirs, and you have to demonstrate that through a permanent job offer. And then you have to also show your accomplishments that would demonstrate that you are outstanding as a professor or researcher. And it's pretty straightforward how you can do that through awards, memberships, publications, judging the work of others because you are internationally recognized in your field. Then Oftentimes, those that are researchers and professors are asked to judge the work of others in their field. Your original contributions, a lot of times you have patents, books, publications, whatever it might be, that would be original authorship of articles and things of that nature, research papers as well. And typically when they're looking at authorship, they're looking at scholarly articles or you being published in magazines that are specific to your area of expertise that would publish you and publish your work and talk about you. And the last thing that they want is a support letter from the employer attesting to these things and that you meet them and that they have this offer for you, and also attesting to what it is that they plan on having you do long-term for them. And we've done many outstanding professor researcher cases, the University of Buffalo and other academic institutions here in the area. And we've helped professors and researchers both go through this process to obtain a green card as either outstanding professor or researcher. So if this is you and you fall into that category and you're in the US on a TN visa, there's a potential that you could make that transition from a TN to a green card as EB-1B.
The EB-2 national interest waiver is another one of those self-sponsored opportunities. To qualify, you first have to show that you have an advanced degree or exceptional ability. An advanced degree, or the foreign equivalent, is essentially anything higher than a bachelor level degree. And you have to, or you can show that you have a bachelor level degree and 5 years of experience through former employer letters attesting to that. So that's how you'd meet that advanced degree requirement. Or you can always, if you don't have that advanced degree, show that you're an individual of exceptional ability. It's a bit lower of a standard than that EB-1A criteria. So what they're looking for is schooling records, letters of from former employers, so professional experience of at least 10 years, licensing in the occupation, evidence that you're commanding a high salary, membership in professional associations, or recognition for your achievements, and any other comparable evidence that you could provide. But once you meet either that exceptional ability or have that advanced degree, you can then argue to the US government that you have an endeavor that's in the national interest of the United States. So what that looks like is essentially an endeavor that has both substantial merit to the US as well as national importance. So Jeremy and I have done these types of cases. The ones that are typically the most successful are always going to be your ones in the STEM professions, AI. We did one for a civil engineer whose endeavor was to improve water infrastructure. So that improving water infrastructure, the need of water helps growing populations. It helps with agriculture, with the US agricultural industry, cooling of nuclear reactors, as well as just general livelihood for US citizens. You need water to survive. So we were able to make an argument of how that had substantial merit and national importance. And that national importance can't just be for your specific area. You need to show how it can be translated across all of the continental United States. So there was case law out there about how someone tried an NIW where they developed a system to detect tornadoes. Well, if you're in, I would say if you're in Buffalo, but we just had a tornado. But typically Buffalo doesn't have tornadoes. So here they would say, well, why does New England care about tornadoes? That's not national importance. But they were able to show how the system that he developed was able to not just detect tornadoes, but was able to work on other giant storms that do affect the entire continental United States. So he ended up winning their appeal in that case. You also need to show that you're well positioned to advance that endeavor. So the US government is going to look to see that you're not just some fresh out of school graduate, that you have the ability to essentially say what you're going to do and actually have that ability to do it. And then on balance, essentially, the US government will weigh, well, what's the substantial merit and the importance of this endeavor to the United States? And how important is it that we protect US workers? And they do a cost benefit analysis essentially to determine is it more beneficial to have this individual in the United States to perform this endeavor than it is to have them go through and get a labor certification? And if the US government feels that having this in you as a foreign national is more important to the United States and the future of the country than going through the labor certification, you have an argument for a national interest waiver.
Yeah, these cases are fun to work on. So are EB1As. All of these are, but and we also just recently did one for an individual who works in the EV industry and works on technology for electric vehicle charging stations throughout the country and expanding that infrastructure. And if you follow anything with electric vehicles, well, you'll know that the infrastructure across the US isn't there to support those. So that's a national interest of the United States as well. Went backwards there for a second. We'll get back on track.
So we talked a lot about employment-based paths to green card. You can also get a green card through family. So if you have a qualifying family member who is either a US citizen or a US green card holder, they can also sponsor you for a green card. And how that works is, like I said, they have to be a qualifying family member. So if you have a United States citizen spouse, parent, or child who's over the age of 21, then you qualify as having an immediate relative of a US citizen. And that there's always a path to a green card for. There's always green card availability. You don't have to worry about those priority dates and that visa bulletin that Jeremy was discussing before. Aside from immediate relatives, then you go to your what's called preference family members. So if you have a sibling who is a US citizen, you're a preference family member. If you are the adult child of a US citizen, so if you're over the age of 21, then you're now a preference family member. And the US government breaks it up even more into, are you married or unmarried? So if you're unmarried adult child of a US citizen, you're considered a first preference family member. If you're a married adult child of a US citizen, you're a third preference. If you're a sibling of a US citizen, you're a fourth preference. And then they go to green card holders. If you are the spouse or child of a green card holder, you're considered a second preference family member. And all four of those preferences are subject to the visa bulletin and visa availability. How that process would work in terms of either immediate relatives or preference family members in getting a green card is, first, your qualifying family relative would have to file what's called an I-130 petition for alien relative. They file that with US Citizenship and Immigration Services to essentially establish that there is that valid relationship between you and a US citizen or a US green card holder. So if you are the spouse, they're going to want to see that you have a bona fide relationship that was entered into out of love and that you got married solely for not solely for wanting to be married to each other, that you didn't do it for an immigration benefit. If you're the child or the parent, they're going to want to see birth certificates. Once USCIS approves that application, all they're saying then is that, okay, you qualify as a family member of a US citizen or a US green card holder. They identify you as this category. Then you have to either, if you're a preference family member, wait for your priority date to be current. If you're an immediate relative, you can go right into filing for your green card application. Similar to employment, you can do that either through consular processing if you're outside of the United States, or through adjustment of status if you're inside the United States.
So, common challenges that you can face during this process, and we're just going to hit on some of the common ones that we see throughout this process. Processing times. Now, they vary significantly depending on your category. We just talked about EB1A, EB1B, and also NIW. these all fall under different preference categories and have different processing times. And under perm, you have EB2 and EB3 are the most common perm categories. And each category has a different preference and has different wait times. So the processing times can be quite lengthy. And in addition, just the standard processing time, as I discussed previously, your country of birth comes into play too. In your country of birth, could put you further back in line depending on where you were born. Now, there is some, depending on your spouse, you may be able to get some relief if your spouse is from a country that has a shorter wait time than your country of birth does. So if you're Canadian, but you were born in India, but you married a Canadian, you may be able to take advantage of your spouse's country of birth because it has a shorter wait time than somebody born in India. So that's something to consider that might help with processing times. So processing times is probably one of the biggest factors when you're talking about going from a TN visa to green card, because you have to time it properly. You have to time, when do I need to extend my TN, or do I need to extend my TN? How do I extend it? Am I going to extend it at the border, or am I going to extend it by mail? It also can be a big factor in determining whether or not you choose consular processing or whether you choose adjustment of status. And part of that has to do with travel restrictions.
Well, the reason processing times are such a huge concern and common challenge with TNs is because the TN is a temporary non-immigrant visa. So your intention when you get the TN has to be temporary. When you're filing a green card application, you're declaring immigrant intent. So those two doctrines contradict. So processing times come into play because you need to make sure that you're establishing the correct intent at each stage of the process.
And glad you brought that up. So intent, very important, but intent is only established at certain stages, right? It's not established when you do the perm, and it's not established when you do an I-140. If you paid attention earlier when we talked about that, those are employer-based applications on behalf of an individual, right? That's an employer saying, hey, we potentially want to offer a green card to this person. It's not
It
until
also
that,
doesn't, no,
yeah,
it also doesn't come into play when you file the I-130. That's a family-based petition that your partner or child or parent is filing for you. So at no point in the perm I-140, I-130 process do you as an individual ever declare your intent.
exactly. But you do, however, declare it when you either file a 485 or you commence consular processing, because that is when you're acting on that I-130 or that I-140 approval. You're saying, hey, this was approved for me, giving me the ability to request a green card. Now I officially want to request it. So once you make that official request through adjustment of status or through consular processing, it can have a big impact on your ability to travel. Because if you're on a TN, the TN, as Rachel said, is non-immigrant. It does not carry with it the inherent ability to go to a green card and maintain the ability to travel and extend your TN status. So once you commence this process, it could impact not only your ability to depart the United States, but also your ability to extend your status while you're in the United States waiting for that green card. So timing is very important. But if done correctly, you can absolutely go from TN to a green card. And in some cases, you can extend a TN depending on how you're processing for it. So careful consideration needs to be taken once you get to the final step of this process to make sure that you have valid visa status while you're waiting for that green card, and if needed, the ability to travel. Also, what are some other challenges, Rachel, that we see?
So another big one is obviously what happens if you have to change your employment. If you're going through this perm process, depending on when you change employment, obviously if you're on a TN and you're going through, like we said, perm I-140, those don't establish immigrant intent yet. So you could still continue to change perm or change your TNs, but you might not want to lose all of the progress that you've made. Well, if you have that approved I-140, you may be able to still maintain that priority date if you get a new employer to start the perm process for you and you're able to get a TN for them to continue working because no immigrant intent has yet been established. If you're kind of already going through the perm process and you haven't gotten to that I-140 stage yet, the perm does need to restart. But even if you are going through and you're, say, at the final end of this TN to green card process, you're in that 485, if as long as it's been pending for 180 days, that 485 has, you can actually switch your employer and you can change employers and have a new employer take on the green card application for you and not have to restart the whole process from the beginning. So that's another big issue that can come up when you're dealing with the TN to green card route and wanting to change employers.
Yeah, it's so you can potentially maintain your priority date, which is huge. In other words, you maintain your place in line. You don't have to start all over and get back in line. You may have to do redo parts of the process, but you get to maintain that priority date and your place in line, which is a very big deal in immigration. You don't have to get all the way back to the back of the line to start.
As long as your position is substantially comparable to what the perm was done for. So if you got a perm done to be the CEO of a company, and then you had a change in careers and you decided you now want to go be a chef, then you'll likely need to have a new perm done and you won't be able to maintain that priority date because it's not a substantially comparable position. But not many people do that. So as long as your position remains something that, as long as it's about 50% similar, then they'll likely can argue that you have a substantially comparable position and you should be able to maintain that priority date or that I-140 application.
And I would say when we're talking to individuals and people have questions about TN visa to green card, the number one challenge is this travel restriction piece of it. Because if you do go from H-1B to a green card, for example, and that's what the rest of the world has to use to go to a green card, you are able to travel. Or if you're on an L1 visa, for example, you are able to travel throughout this process. But with a TN, those travel restrictions, especially if you work for an employer that sends you, all over the world on business, it's something you really need to pay close attention to during this process. Finally, common questions that we receive. So under the perm category, you have EB2 and EB3 categories. So Rachel, how do we know whether or not somebody's an EB2 or an EB3?
So determining if you're EB2 or EB3 is going to come down to those qualifications that your employer put in that prevailing wage. So at the very start of that perm process, your employer has to say what the minimum qualifications are for the job. If they say that they only require maybe 4 years of experience, no education, then you're an EB3. If they say they require a bachelor degree, you're an EB3. But if they require a master's degree or higher, then they require and are requiring an advanced level degree, then you're going to be an EB2 qualification. But what's important to kind of remember here is that it doesn't revolve around what your qualifications are. It's what your employer says the qualifications are for the job. So even if you have a PhD, if your employer's only requiring 5 years of experience, then you're going to be an EB3 classification.
Yes, and that's very important to understand. Also, what your employer is requiring must be consistent with the Department of Labor says that position would require too. You can't just make it up. So very important. So I think we kind of covered this a little bit, but if we start the green card process and we're on a TN, can I still renew my TN?
So as long as you haven't declared that immigrant intent yet, you can still renew your TN.
So if you just have an approved I-140 or an approved I-130 and you haven't acted on that yet, maybe your priority date isn't current, maybe you just don't want to move to the United States yet permanently. You haven't declared your immigrant intent. So you're still a non-immigrant until you change that intent, and you would still be allowed to extend your TN. Travel during the process, and we covered this one. It depends. If you filed for an adjustment of status and you're on a TN and you haven't received authorization to travel yet, then you can't travel. Now, you can travel, but if you do, you will abandon the application. So I say can't, because you shouldn't be traveling, because if you do, USCIS will consider your application abandoned and they will deny it. And then good luck getting back in the United States, getting another TN again, because you've already declared your immigrant intent. The border officers are probably not going to let you back in if you travel during this process. So highly advised not to travel, because if you do, you're going to potentially have to start the process all over again, and you're going to severely complicate it, because once you file for that green card, you've declared that immigrant intent, and it's hard to retract your intent once you've established it. Rachel, you can take the next one.
All right, so what happens if my TN expires before I receive my EAD or green card? So the EAD is an employment authorization document. When you file that 485 application, you are entitled to also file work authorization on the basis of having a pending green card application. So hopefully your TN does not expire before you get that EAD or green card. Hopefully it's all timed correctly, but government processing times are unpredictable. So if your TN does expire before that EAD or green card comes through, then you technically do not have authorization to work. However, in immigration law, there is an exception that essentially says that if you're going through the green card process as an employment-based green card and you lose your work authorization status before you get that green card or EAD, you technically can have no more than 6 months of unauthorized work. So if you find yourself in that situation, you technically can work for at least 6 months without proper authorization to do so, and USCIS will forgive it when they adjudicate the green card. So, Jared, go ahead.
Yeah.
I was gonna say, how does the process work for my family members?
Well, it has to be a certain family member to qualify. And we run into this question actually a lot. How does it work for my family members? Because Canada has common law marriage. The United States does not recognize Canadian common law. So when we're talking about family members, we need to be specific. It has to be a spouse. In other words, you have to be legally married for your spouse to qualify. And children have to be under the age of 21 to qualify as well.
They also have to be unmarried.
Unmarried, good clarification. Unmarried children under the age of 21, and your lawful spouse through actual marriage, not common law. Now, if they are, then they qualify along with you to then request a green card at the proper time, and they will get green cards just as you will. Now, the I-140 or I-130, depending on how that was filed, and we'll stick with an I-140. The I-140 is only filed for the employee, where it will list the beneficiaries, the spouse and beneficiaries, and spouse and children of that employee. Then it allows that employee and their family members to individually file their own I-485 applications and consular processing as well. But they're individual at that stage. So it gets kind of complicated, whereas if you just focus on the employee throughout this entire process, all the way up into the finish line, then at the finish line, if you're doing adjustment of status, every family member has to file their own application requesting that green card. And again, unmarried children under 21 and a spouse. How long does this take, Rachel?
So it really depends on your priority date, but if we're looking at kind of someone who's maybe rest of world, they're doing it EB2, EB3, you're looking at maybe 2 to 3 years right now with government processing times. Obviously, if you're someone who's Indian born or Chinese born, they have significantly longer backlogs. So it can take 15, 20 years for those individuals, unless they get cross chargeability, as we discussed, and they're able to use, say, a spouse's country of birth. But right now, with the Department of Labor, you're looking at least a 2-month process, or 2-year process, just with labor certification. And then I would say at least another year with even the I-140 stage. So you're looking at a pretty lengthy time right now, but it all depends on those priority dates. So if I have an approved EB2 or EB3, can I do an EB1?
Absolutely. You know what? You can also do an I-130, right? You can
You
do
can,
all
so
of
you
those
can,
if you want. You
so
can
as long
apply
as you're
under every
qualified, you
category,
can
right?
file for it. Yep,
Yep.
as long as you're qualified to have that application, you can file for whatever you're qualified for.
Exactly. You're not limited just to one category. Now, it doesn't always make sense to do multiple categories. So typically, someone would want to change a category because the wait time in their current category is super long. And then they find out they qualify under another category where the wait time is shorter. So EB1 has the shortest wait time. So if you're stuck in a EB2 backlog for years, and you think you qualify for an EB1A, well, it may push you up in line and get you that green card faster. So can you do that? Yes, absolutely you can. And in some cases, it does make sense. And the client I referenced earlier, that's why that client wanted to try an EB1A, even though they had an approved NIW, because NIW is EB2 with a much longer wait time than an EB1A. You get your green card faster. So what is the significance of a priority date?
So I think we kind of discussed this during the presentation already, but that priority date essentially tells you when you're eligible for that final step of applying for the green card, either with the consulate or that 485 application. So your priority date, if you're going through PERM, will come when you file the labor certification. If you're going with one of those processes without PERM, it'll come when you file that I-140, or family-based, it'll come when you file that I-130. And so that priority date essentially tells you when you're allowed to ask the US government for a green card.
Place in line. It's going to determine, and then in the end, it goes back to that question: how long is this going to take, right?
Right.
Well, what's your priority date, and what category are you? That's how long you're going to have to wait. So, unfortunately, depending on where you're born, it's a big factor, and also what category are you? EB1A or EB2 or EB3? But we help individuals go through this process all the time. Help people transition from TN to green card, and we're out here trying to dispel the myth that that this isn't possible, because it is. It's actually the exact same process to go from a TN to a green card as it is to go from an H-1B visa to a green card. Thank you for tuning in today to this webinar and humoring us as we discuss TN visa to green card. If you have any additional questions about this process or U.S. immigration in general, our contact information is on the screen. Feel free to reach out to us at Richards and Drusik Immigration Law. We'd be glad to assist you with your immigration needs. Thank you, and you have a great day.